Now, let's discuss how to appeal assessors' decisions on abatements to the Appellate Tax Board, or ATB. Who can appeal to the board? Attorneys at law admitted to practice before the courts of the Commonwealth may practice before the Appellate Tax Board. In addition, persons may appear or act for themselves before the board. The Appellate Tax Board is an administrative agency which functions in many respects like a tax court. The ATB, as it is referred to, has jurisdiction or authority to hear appeals from actions of local assessors on taxpayers' abatement applications. ATB decisions may also be appealed. Appeal of ATB decisions is made to the appeals court and then to the Supreme Judicial Court. The ATB has 5 commissioners appointed to staggered 6-year terms by the governor. The governor designates 1 commissioner as chair. The Appellate Tax Board can grant or deny an abatement in the appeals process, based on the law and facts it finds upon hearing the evidence in the case. The assessor's decision does not bind the ATB, so the ATB gives the taxpayer a second bite at the apple to obtain an abatement. The first step in appealing the assessor's action is for the taxpayer to file a petition under the formal or the informal procedure. The date you acted on the taxpayer's abatement application, or the date it was deemed denied, starts the clock running on the taxpayer's right of appeal to the Appellate Tax Board. The taxpayer has 3 months from the action or deemed denial of the abatement application in which to file a petition with the Appellate Tax Board. However, if you do not send out a notice of your action or the deemed denial within 10 days of the action or deemed denial, the taxpayer gets an additional 2 months to appeal. This procedure is referred to as the petition for late entry. After you act on or are deemed to have denied an abatement application, you lose jurisdiction to take further action. However, a taxpayer's right to appeal means you can abate in final settlement of the abatement claim during the 3-month time period the taxpayer could file an appeal. In addition, once a taxpayer files an appeal, you can settle the claim. Jurisdiction is the decision-maker's authority to act. Here, the authority of the Appellate Tax Board to act on a taxpayer's appeal of the assessor's action on an abatement application. There are legal requirements that the taxpayer must meet to establish jurisdiction in the Appellate Tax Board for an appeal. Without jurisdiction, the ATB cannot act, and the taxpayer cannot get a hearing or a decision on the appeal. The general rule, subject to exception, is that the tax must be paid in order for an appeal to the ATB to proceed. For the ATB to have jurisdiction to hear a personal property tax appeal, the taxpayer must have paid 1/2 of the amount of the tax assessed at the time the appeal is filed. Note that a lessee of personal property cannot claim an abatement of an assessed tax, while in some cases tenants of real property may do so. However, if the lessee is assessed as a person in possession of personal property, the lessee may apply for abatement and appeal the assessor's decision. If a real estate tax for the fiscal year is $5,000 or less, it does not have to be paid for the ATB to have jurisdiction to hear the appeal. However, for the ATB to have jurisdiction to hear an appeal where the real estate tax for the fiscal year is more than $5,000, the tax must have been paid without incurring interest. This means all installments, preliminary and actual, must have been paid on or before their due dates. If the tax for the fiscal year at issue was more than $5,000, but the 3-year average tax on the property is $5,000 or less, the taxpayer may also proceed with an appeal without paying the tax. The ATB may waive the payment requirement when at least half of the tax is paid. However, this procedure is rarely used. Even though many taxpayers are unaware of this exception to the general rule that taxes must be paid, the ATB has generally not relaxed the general rule requiring payment of the full tax. Cities and towns depend on the cash flow provided by the predictable stream of revenue to pay their bills, and they set aside amounts in the overlay account to pay for necessary abatements. The Appellate Tax Board will only accept appeals from actions by the assessors, including deemed denials. A taxpayer does not have standing to appeal to the ATB if the taxpayer did not file a timely abatement application with you. In other words, The ATB is purely an appellate body that reviews taxing decisions you make in the first instance. A taxpayer must comply with all jurisdictional requirements in order to get a hearing and decision on an appeal. Let's review what we have learned in this lesson. Taxpayers who disagree with assessors' decisions on their abatement applications may appeal to the Appellate Tax Board, the ATB. ATB decisions may be further appealed to the Appeals Court and then to the Supreme Judicial Court. The taxpayer must file the appeal on time, have paid the tax, and meet other requirements for the ATB to have jurisdiction to hear and decide the appeal. The deadline for filing an appeal to the ATB is 3 months from the date an abatement was granted or denied, or deemed denied. As a general rule, the tax must be paid, but this requirement depends on the type and amount of the tax.